welcome to today's webinar. I'm Matt Gibbs, Principal Advisor, Immigration Engagement, and I'll be your host for today's presentation. I hope you're all managing through these challenging times and that you're all safe and well. Thanks for joining us today to talk about the employer accreditation portion of the Accredited Employer Work Visa Policy. Some of you know the Accredited Employer Work Visa is a 3-check process. However, today we will be talking just about the first check, which is employer accreditation. But before we kick off, just a few housekeeping items. We are recording today's session. Hopefully we don't have any technical issues and I don't go fluffing my lines. And we will email you a link to the recording later in the week. As I say, we are focusing on employer accreditation today. So our presentation to you is based on the most commonly asked questions we've received so far about the accreditation process. There will be another webinar later about the other 2 checks, that is the job check and the visa application. So save your questions about those 2 portions until the next webinar. We did also receive some questions that are decisions yet to be made by the Minister and the government. And unfortunately, we aren't able to answer those questions today, as we do need to wait for the government to make and finalise those decisions. We have also enabled the Q&A function of this webinar, so you can submit additional questions as we go. If we have time, we will answer some of those live questions. However, if the question you want to know has already been asked, you can use the upvote feature to give this question a thumbs up, and that will let us know that it's a popular question. Finally, even if we don't get to answering your question today, any questions you do submit will help us understand what you want to know more about. We can include this information on our website and in our next webinar, which again is the job check and visa application. So I do hope you get some good value out of today's session. Let's take a look at the agenda. I'll start by giving you a quick refresh about the Accredited Employer Work Visa. Then I'll hand over to my colleague, Nick Eldis, Director of Policy Integration, to tell us about how to become an accredited employer under the new policy. This will be the bulk of the webinar. There's a lot of information to get through, but this is all available on our website. So please rest assured you will be able to go back and find this information after the webinar. After that, we'll give you a heads up on what's to be covered in our next series of webinars. Again, that's the job check and the visa application. You'll also see that there are a few more names with me on today's webinar. These are our backups, our extras, if you like, from our policy and operational policy teams, just in case we need to call in additional knowledge to be able to answer the questions that you have asked us. As I say, we do want to be able to give you as much information today as we possibly can. All right, so to start off, we'll do a quick recap about what the Accredited Employer Work Visa is and why the government is introducing it. So in 2019, the government announced changes to temporary work visas. The intent of the government's new policy is to ensure New Zealanders are first in line for jobs and to increase expectations on employers to employ and train more New Zealanders. The new policy aims to simplify the visa application process and make it easier for accredited employers to fill genuine skill shortages when it is clear that there are no New Zealanders available to do the job or who can be trained up for the role. The changes will also combat migrant exploitation and misuse of the immigration system and give migrants more certainty about the role they're applying or coming to New Zealand for. The outcome of this work is to reduce New Zealand's reliance on lower paid temporary migrants, better address our productivity, skills and infrastructure challenges, and increase the overall level of migrants coming to work in New Zealand. The Accredited Employer Work Visa system has 3 checks. Firstly, the employer accreditation, and that's what we're talking about today. Employers need to be accredited to hire a migrant worker under the new policy. Second, the job check. The job itself must also be checked. This involves the employer checking whether there are any New Zealanders available to do the job. If not, immigration checks the job pays the market rate, the employment complies with New Zealand employment laws and standards, and that it meets the medium wage threshold if necessary. And finally, the visa application. This is where the temporary migrant worker applies for an accredited employer work visa. The migrant must meet immigration's health and character requirements and any skills and experience requirements that were stipulated as part of the job check. And just to re-emphasize, today we're talking about the first check, the employer accreditation. So in practice, how does that compare with the old system? Well, the main changes are the new accredited employer work visa will replace 6 of the existing temporary work categories. The old system is migrant-led. The new system is led by the employer. Previously, some employers were accredited to hire under our talent policy. In the new system, all employers wanting to hire migrants on accredited employer work visas need to be accredited. The requirements for the new accreditation system are different to the old system. You'll hear more about the requirements when I hand over to my colleague, Nick. The accredited employer work visa will, the accredited employer work visa will be introduced on the 4th of July this year, in line with step 4 of the government's plan to reconnect New Zealand to the rest of the world. This is when migrants can apply for the visa, both onshore and offshore. Other important dates: applications for employer accreditation open on the 23rd of May this year. Applications for job checks open on the 20th of June this year. And the implementation date for the actual accredited employer work visa remains 4th of July this year. Remember, the accredited employer work visa replaces the essential skills work visa, which closes to applications on the 3rd of July this year. This is the last of the 6 visas to close that are being replaced by the accredited employer work visa. These dates should still give employers time to prepare for applying for accreditation and job check. For most employers, accreditation will be simple and the assessment relatively low touch, and immigration will work to process applications quickly. Just remember, employers do not need to apply for accreditation or a job check on these dates unless they are planning to use them shortly after the 4th of July. And employers can still support migrant workers on essential skills work visas up until the 3rd of July this year, 2022. Okay, I just want to emphasize that last point from the previous slide because it's been a common question many of you have asked, and that is, how does this impact people on an existing visa like essential skills? Well, migrants can continue to work under the conditions of their current visa until it expires or they no longer meet the conditions of that visa. Employers do not need to do anything until they want to hire a migrant on an accredited employer work visa. Okay, we're going to move now into the detail of the accreditation requirements. So I'm going to hand over to my colleague, Nick. Nick will introduce himself. Over to you, Nick.
Thanks, Matt, and thanks for that overview. So for those of you who haven't met me before, I'm Nick Aldis. I'm work in enablement at Immigration New Zealand, and I'm the Director of Policy Integration, and I'm the business owner for the Accredited Employer Work Visa implementation. So it's a very auspicious day today. Of course, there's a next step in the Reading New Zealand phasing has happened. So we've opened the door to Australians, and there's a cyclone bearing down on us. So there's a couple of exciting things going on in addition to this webinar. So what I'm going to do today is talk you through the specific details of the accreditation requirements. It is fairly detailed. I was talking with Matt earlier today. The accreditation requirements, particularly for franchisees and for employers who place workers with controlling third parties, are reasonably detailed. So I'm going to talk through them at a high level here this morning, and then what we'll probably do is have a specific session shortly to work through the specific details of those two parts of the system, because they're quite specialised, but only affect a reasonably small number of employers. All right, so I'll launch in. So the type of accreditation that an employer needs will depend on how many migrants on accredited employer work visas they intend to hire and the nature of their business. So standard business models can choose between standard accreditation, that's for employers who want to have up to 5 migrant workers on accredited employer work visas at any one time, or high volume, and that's for employers who want to have 6 or more migrant workers on accredited employer work visas at any one time. So this only includes work visas migrants on accredited employer work visas. So if an employer has migrants on other visa types, for example, working holiday visas or partnership work visas with open working conditions, they will not be counted towards the total. That also includes student visa holders who'd be working part-time. So there's no difference in the requirements for standard and high volume accreditation, although further requirements for high volume employers might be considered in the future, but not initially. So employers can upgrade from standard to high volume accreditation at any point during their accreditation period. There is a small fee associated with that though. So if they originally only intended to hire 5 or fewer, and it turns out that they've expanded or that they need more workers, then they can upgrade to high standard. The additional fee reflects the additional risk assurance activities that Immigration New Zealand may have to undertake as the impact of non-compliance overall increases with the greater number of migrants employed by an individual business. All employers must meet minimum accreditation criteria, and franchisees and employers that want to place migrants with controlling third parties, mainly that includes labour hire companies, will need to meet additional criteria to get accredited, and there's no limit on the number of accredited employer work visas that franchisees and labour hire companies can hire. So I'll just talk through the minimum requirements for all employers. So all employers have to meet these standards, and this is to ensure that only employers who meet New Zealand employment, immigration and business standards have access to migrant workers on accredited employer work visas. So the general criteria are: an employer must have a viable and genuinely operating business, complete settlement support activities for their accredited employer work visa holders, comply with immigration, employment and business standards, pay any recruitment costs. That doesn't include the migrant work visa fee, complete employer online learning modules, and allow their accredited employer work visa holder time to complete the online modules too. So what I'll do now is I'll just cover off each of these individual criteria in more detail. So firstly, to be considered a viable and genuinely operating business, employers must meet one of the following criteria. So, and these are not inclusive, so you only need to meet one of them. To be profitable before depreciation and tax over the last 24 months, have positive cash flow for each of the last 6 months, have sufficient capital and external investment or funding, and have a plan to ensure that the business remains viable. As well as this, employers must be registered with If you're a partnership or sole trader, you must not be bankrupt or be subject to a no asset procedure. So evidence of meeting these requirements. So for businesses operating for less than 12 months, they have to provide evidence of this criteria, that this criteria is being met at application. I think we're on the next slide, Frankie. Yep. So evidence for a business operating less than 12 months may include evidence of startup capital or funding, cash flow or revenue forecasts, contracts for work, GST returns or PAYE returns. Most other employers will not need to provide this evidence up front, and the accreditation criteria will be asking for is just largely through declarations. So you will not need to supply this evidence up front if you've been operating for more than 12 months. However, evidence may be required to show you meet the requirements once the application is submitted or at any time during your accreditation. So INZ will be undertaking a program of post-decision assurance and verification, which may require them to check the evidence that the criteria is being met with specific businesses. And where this is the case, the business will be contacted. Settlement support activities. So say at the outset that these are not intended to be particularly onerous or burdensome, and the information that we're asking be provided to prospective migrant workers is all readily available online. So it's just a matter of the information being prepared in a pack for them. This won't be tested at accreditation, and it's an expectation that it will occur post recruitment and as part of the onboarding process, and you'll be asked to declare, or employers will be asked to declare as part of your accreditation application that they will do this. So the information that we're asking to be provided includes how to get an IRD number, things like relevant industry training and qualification information and options, the standard things on specific or industry-wide hazards, information on accommodation options, transport options in terms of how to get to work and that sort of thing. General information on things like cost of living, how to access healthcare services, Citizens Advice Bureau services, and information about relevant community groups. So it'll vary a lot depending on where the migrant is settling as to the sorts of information that would be provided. As I said at the outset, it's not intended that we have a hard and fast list, although we will provide as much guidance as we can and as much information as we can about where to get it, so that information can be provided. For the avoidance of doubt, settlement activities don't need to be completed multiple times by the employer for the same accredited employer work visa holder if the information provided has not changed. So if you're rolling a visa over for or looking to the migrant needs to obtain a new visa, you won't need to provide that information again if nothing substantial has changed. And as I mentioned earlier, this will be initially required as a declaration that this has or will occur. Just talk about settlement support activities a little more. Accredited employer work visa holders should be directed to appropriate websites with the information about living in New Zealand. So, such as the websites listed on this site. And assembling information for work visa holders, employers can get information from WorkSafe from us. We've got a whole lot of settlement information on our websites, Employment New Zealand, IRD, and websites like New Zealand Now. Employers must be able to provide documentation to show settlement support has been provided, such as the actual information given to migrants. So if you're providing a pack of links and that sort of thing, you just need to hold it on their file. A register signed by the work visa holder and any email records between employers and the migrant. Clearly, this is a post-accreditation issue, and it's post the issuance of the visa, but it would be required to be provided if requested by Immigration New Zealand. So just a note on employment, immigration and business standards. So employers and their key people, that's directors, hiring managers and so on, must not be subject to the stand down period or permanent ban from hiring migrant workers. Key people include directors of the company, partners in a partnership, office holders like school principals, and any other person who can influence an organisation's compliance with employment and immigration law. Stand-down periods and permanent bans are imposed if an employer breaches minimum employment conditions or is convicted of specific Immigration or Crimes Act offences. So employers or their key people must not have employed a migrant who did not have the right visa or visa conditions to work in that role, or provided false or misleading information to Immigration New Zealand. There are specific Immigration Act and Crimes Act offences that can lead to a stand-down period or a permanent ban. Once an immigration stand-down period has ended, the employer must show that they've addressed the non-compliance and taken steps to make sure it will not happen again. Employers and their key people must not be banned from acting as a director or have a pattern of immigration offences in other businesses they or their key people have been involved in. A business with compliance failures cannot be closed and opened again under a new name to avoid those failures. And so we'll still take the compliance issues in the previous businesses into account. Just a note on the online employment learning modules that need to be required. So both employers and accredited employees must complete Employment New Zealand's most recent online employment learning modules. For employers, this needs to include hiring managers, human resource managers, and if you're a sole trader, you'll need to do it, and partners. So it only applies to those directly involved in hiring accredited employer work visa holders and not other employees. So, for example, if you're a reasonably large organisation and you're a hiring manager, you don't need to complete this until you're looking to employ someone on an accredited employer work visa. So if all your workers are either New Zealand citizens or residents or work visa holders with open work rights, then this won't need to be done. Employers must keep records of all the modules being completed by their staff, and the modules must be completed within every accreditation period and finished before that period ends. Employees must be allowed time to complete the online employee modules on employment rights during paid working hours within a month of starting employment. And again, employees just need to keep records of the modules being completed. So employers must pay all recruitment costs in New Zealand and outside New Zealand. They cannot be passed on to the visa applicant or migrant, and this includes but isn't limited to job advertising, recruitment agency fees, your employer accreditation fees, job check application fees, things like trade testing, and tools where the ownership is retained by the employer, or any compulsory training or induction. It doesn't include migrant worker airfares, and you must not charge fees outside New Zealand, which would be illegal if charged in New Zealand, including payment to secure a job, bonding agreements that legally binding workers to a business, or deductions that are unreasonable, not agreed in writing. So employers will just be asked to make a declaration that any of these fees and costs will not be charged to the visa applicant. And as I mentioned earlier, the visa application fee itself isn't included as a recruitment cost, so that can be met by the visa applicant, although of course employers are welcome to pay those as well, so nothing preventing them from doing so. So I'll just talk a little bit about the additional requirement for franchisees and companies that place workers with controlling third parties. So franchisee employers will need to meet additional requirements on top of the minimum requirements. They will need to have been operating for at least 12 months and demonstrate that at least 15% of the workforce are New Zealanders or residents who are guaranteed at least 30 hours of work a week. If an employer has a new business and has had 12 months experience in another business they own which sells the same goods and services as the new business, they can use that experience to meet the accreditation requirements. So a business is considered a franchisee employee if they have purchased the right to use a pre-existing business system created by a third party. They have a business that uses a brand, trademark, advertising, marketing channel, or a commercial symbol owned by a third party. That third party business controls certain activities or structures within their business as set out through an agreement, operational guideline, or terms and conditions document. So many of these activities in the third bullet point may cover one or all of the following features: a continuing financial performance or reporting obligation to the third party, an ongoing obligation to pay the third party any fee or percentage of profits generated by the business from the rights of use, restrictions, expectations, or control imposed by the third party over where the business can source goods and services and or how to set up or run the business, and restricted ability to refuse requests by the third party, raise concerns or complaints regarding the third party, or a lack of ability to easily exit or terminate the agreement. So as I say, there's a fair amount in there in terms of the definition of franchisee and the requirements there. And we'll look to set up sort of a separate session to go through that in more detail. So placing accredited employer work visa holders with controlling third parties. So the primary business model here are labour hire companies, and additional accreditation requirements apply to these sorts of employers. The migrant's direct employer must be, so the requirements are that the migrant's direct employer must be accredited. So the entity named as the employer on the migrant's employment agreement must hold accreditation. And the definition of a controlling third party is taken from the Employment Relations Act. So I'll just run through what that is. So the controlling third party is a separate legal entity to the direct employer named on the worker's employment agreement, has an arrangement of contract with the employer allowing its employees to perform work for the benefit of the controlling third party, and can direct or control these employees as if the controlling third party was the direct employer. So it's considerably more detail on the requirements for accreditation for both franchisees and employers who place workers with controlling third parties on our website. So if you've got a particular interest in this area, please go and visit it. And as I say, we have a separate session just covering that off. So a common question we've had is, what if I place an accredited employer work visa holder in a different part of my business? So a controlling third party is a separate legal entity to the direct employer. So placing a work visa holder in different parts of a single business is not considered placing migrants with a controlling third party. So you would not need to have that type of accreditation. So I'll just go through a couple of examples of where an employer does and does not need to meet the extra accreditation requirements to place their migrants with controlling third parties. So in this example, a New Zealand bank is an accredited employer. New Zealand Bank employs migrants on accredited employer work visas. The bank places those migrants to work with a subsidiary company, the INZ Share Trading Company, which is a separate legal entity and has its own New Zealand business number. New Zealand Share Trading Company is where the migrants work and carry out their duties. The migrants' work benefits the New Zealand Share Trading Company, and the company can control and direct the workers similar to a New Zealand bank. Therefore, the New Zealand Share Trading Company is considered a controlling third party. The Share Trading Company does not need to be accredited to have migrants placed in their business by an accredited third party, in this case the New Zealand Bank. New Zealand Bank needs to meet the extra accreditation requirements to place its accredited employer work visa workers with a controlling third party. So if the Share Trading Company employs accredited employer work visa holders in its own right, it will need accreditation, but accreditation is not required to receive migrant employees that are employed by an accredited employer. But that's clear. So another example, in this scenario, a migrant worker hired by a New Zealand bank is hired to work in the retail banking division, but they are offered a new job in the business banking division of the same company. Moving an employee within a single legal entity is not considered to be placing a migrant worker with a controlling third party. But if the employee is changing roles in the cities or region, a variation of conditions may be required, but it would not need to meet the additional accreditation requirements for a company that's placing somebody with the controlling third party. They could just have standard accreditation in their example. All right, phew. So as I say, there's quite a bit of detail in there around the additional accreditation requirements for franchisees and so on. They'll only form a reasonably small proportion of the number of accreditations that we're expecting. We expect that 85% will be either standard, just have to meet the standard accreditation requirements. So just a note now on timings and fees. I think as Matt mentioned, employers will be able to apply for accreditation using our online system from the 23rd of May this year, so in about 5 weeks. To apply, employers will need to have a New Zealand business number and to pay the accreditation fee. And the system will guide you to provide all the information needed depending on the type of accreditation being applied for. And detailed information is available on our website. And as Matt mentioned, we'll be providing the information from this webinar as well. And Immigration New Zealand will retain information previously supplied when applying for renewed accreditation. So that process will be very streamlined and straightforward in most cases. Just the periods of accreditation. Initial accreditation for everybody, once approved, lasts for 12 months. If employers apply to renew their accreditation, franchises and employers placing migrants with third parties will be granted accreditation for a further 12 months. All other employers will be granted accreditation for 24 months. So just say that again, the initial period of accreditation for standard employers is 12 months. At renewal, it will be issued for 24 months, which is around 2 years. To ensure employers who apply early aren't disadvantaged, and employers accreditation will be valid for 12 months from the 4th of July, which is the day the new visa opens to applications, even if the accreditation is granted before this date. For example, if accreditation is granted 20 days before the accredited employer work visa opens on the 4th of July, the accreditation will be granted for a duration of 12 months and 20 days and will expire on the 4th of July 2023. Just to note also, though, that if an employer has got existing migrants working for them, or they're not looking to hire migrants on the new visa immediately, then they can wait until they know that they're going to need to, or they're looking to engage migrant workers before applying. So there's no absolute imperative to apply on day one unless they're looking to engage migrants very early in July. Noting also that you can still use the essential skills visa for onshore applicants up until the 3rd of July. So just a note on the fees. You can probably read those for yourselves, but standard accreditation is $740. High volume is $1,220, with the upgrade fee for employers being $480. Employers wanting to hire migrants place migrants with controlling third parties, for them the fee is $3,870, and for franchisees it's $1,980. Reconsideration of a declined accreditation there will be an application for that, and that will be $240. So we had a common question about whether employers who are currently accredited under the accredited employer system need to get accredited under the new system. The policy requirements for the new system are different to what we have now, and so employers that are accredited under the previous system will need to apply and meet the new policy requirements when they want to begin hiring migrants on the new accredited employer work visa. So any visa holders they currently have with them, their visas will continue, and they won't obviously need new ones. And if you're not intending to employ new migrant workers, they will not need to get accredited immediately. But employers who hold accredited employer status on the 23rd of May this year, with 6 months until expiry, will not need to pay their first accreditation fee. So just note that. So just recognising that people have allowing people to get the period of accreditation without charge, but they will need to apply. Okay, gosh, that's all from me. So I'll hand back to Matt for a recap, and then we're probably going to have a little bit of time in for Q&As. Matt.
Right, thanks very much, Nick. You're right, that is a lot of information there, but thank you very much for stepping us through it in so much detail. I'll just reiterate a couple of points for some that have just recently joined us. We have recorded this session and we will make it available later to participants. Also, I just want to re-emphasize our website. All of this information will be made, is available on our website, and we will continue to update as more information comes to hand. Nick also did mention the possibility and the likelihood that we will have an additional webinar which gets into more detail around franchisees and third parties. And I can see from some of the questions that that will be an important issue for some. We'll also be able to, as far as we can shortly, address questions in the Q&A. But before we do, I'd just like to do a very quick recap of what we've heard today. So the Accredited Employer Work Visa system has 3 checks, as you know, which will simplify the visa application process and make it easier for accredited employers to fill genuine skill shortages when it is clear that there are no New Zealanders available to do the job or who can be trained up for the role. Employers must meet minimum requirements for accreditation, and some employers, like migrants with controlling third parties, must meet further requirements. And once again, we'll look to be having additional webinar about those franchisees and third parties. Accreditation can be applied for from the 23rd of March this year, 2022, and most applications won't require much evidence to be provided up front. As I said, we will be looking at a light touch for most application processing. A reminder that you don't need to apply for accreditation until May unless you plan to start using accreditation shortly after that date. So that's an important note as well. The job check is the next step in the process, which opens on the 20th of June, followed by the launch of the work visa on the 4th of July. Information about these checks will be released when it is available, and will be supported by another webinar. And we'll come back to you ahead of time with more information about that webinar. Please keep an eye out for the invitation as it comes through. All right, you've heard a lot of detail about accreditation today, and I hope that you find this information useful today. As I say, it'll all be on our website, so I really do encourage everybody to go to the website. Please take time to check it out, and once again, a recording of our video will be made available to you. Now we've got some time. And I see that we've got a number of questions. I'm going to ask my colleague, Rob Perry. Many of you will be familiar with Rob, of course, who's going to facilitate this session. So I'm going to hand over to you now, Rob. Thanks.
Thanks very much, Matt. And hi, everybody. Got a bit of time for some Q&A and just be going through the most popular ones, despite the fact that we may or may not believe that we've answered it, because obviously this is about you and seeking clarification and confirmation, which is important. So, Nick, the most uploaded question is, if an employer wants to hire an essential skills work visa holder after a VOC, do they need accreditation? Our understanding is that the employee will still be on an essential skills work visa after the VOC, so the employer should not be requiring accreditation. Can you just clarify that?
Yeah. That is my understanding also. So if they're eligible for a VOC, then that's what will be granted, and they continue on the essential skills work visa, and the accreditation requirements don't apply to employers who have people on essential skills visas. I might just quickly confirm that with my colleague Lena, who's on the line. That's correct, isn't it, Lena?
I am not sure. I can't actually confirm that. Sorry, there might be a little bit more work to be done on VOCs. We've had decisions around VOCs for accredited employer work visa holders, of course, and they would need accreditation. But yeah, that is also my understanding, but can't confirm. Sorry.
That's okay. So so that's our understanding, but we'll confirm that and let you know. If we've got that right.
Excellent. Thanks very much, Lena and Nick, and obviously a very good question. The next most common questions, Nick, are employers required to complete the online employer modules on employment rights before they apply for accreditation?
So my understanding again about how this works is that it would need to be completed before they have somebody engaged with them on a visa, but it's not required for accreditation, but they'll be asked to declare that they will undertake it. But again, Lena, sorry, in terms of the instructions. Is that...
Yes, that's pretty much correct. So the requirement and instructions is for specific people within your organisation to complete those modules throughout, so within the period of your accreditation. So for your initial application, you're not in an accreditation period, so you don't have to do them before your very initial application. And then, as Nick mentioned, in practice for that initial application, it will work more like a declaration or a commitment. And then you'll have to do them before your next application and every accreditation period after that.
Great. Thank you very much indeed. Can we get confirmation as to which parts of the application will be determined by AL versus a warranted case officer?
I think Casey means AI rather than a warranted case officer. So there are significant parts of the, we're asking for declarations to be made, which are essentially you check the box on the application form, and we won't be providing evidence to be uploaded. So in those cases, there's nothing for a warranted officer to check, and so those sorts of things will flow through the engine without requiring verification, unless the application hits on an alert or a warning where documents are required to be submitted. In those cases, that they'll be available to be checked by an immigration officer, and then the final decision on the granting of whether the accredited employer application meets instructions will obviously be made by an immigration officer. So, Casey, I hope that makes sense. If not, I'm happy to have a chat to you about it.
Thanks, Nick. And another question that is impacting decisions as to whether to become accredited that we really need answers to now is what partner working rights will exist. Will it be that all partners of an AEWV holder will qualify for work rights, given all will be on Medium Plus?
So the answer to the question is from the 4th of July, existing work rights for partners will be in place. So you can apply for a partner will get an open work visa along the lines of a partner or an essential an essential worker. but there are some policy decisions required around kind of how that looks into the future. So that may be subject to change as immigration policy periodically is.
Thanks, Nick. Both settlement support information and online learning modules are all in English. Is the employer expected to translate them for a migrant worker who does not have English as their main language?
So I guess this is where common sense needs to be applied. So if they can't understand English sufficiently to be able to absorb what they're being told, and we don't have the material translated into the language that the migrant speaks, then that would be our expectation using sort of translation services and so on. I mean, just need evidence that had been done.
Great, thanks, Nick. Nick, you've actually talked this through, but it has been well received. Just could you? The question is, can a new startup business apply for accreditation? And I appreciate you've covered it, but it does seem to need a bit more clarification.
So yes, they can. The essential difference is that they would need to provide documentary evidence of their financial sustainability, so what their funding levels are. So the presentation's got the details about what will be asked for there, but there's nothing that prevents them from doing that. Only difference is with franchises, they need to have been in operation for 12 months, Lena, at the outset.
Yes.
Yeah. So a franchise startup can't. But any other type of business can.
Thanks very much, Nick. Nick, some employers agree to cover the immigration advisor and INZ fees for their visas, but in the form of a loan, which they then deduct once in New Zealand, earning New Zealand dollars. This is not to be confused with the employer's own immigration-related advisor fees. The prohibition on passing on visa costs needs to be clarified, as we assume it is directed only at those fees the employer themselves are obliged to cover, i.e. advice to the employer. INZ fees for employer-led parts of the process.
Yeah, that's correct, Katie. So in that circumstance, there's no requirement for the employer to meet those costs. So if the visa holder or the visa applicant engages a immigration advisor, that's up to them. And the visa fee visa fee itself, is visa application fee, is not required to be paid by the employer. If there's a loan arrangement in place, that obviously needs to be that needs to be a legal arrangement. But as long as it meets any legal requirements, there'd be nothing in instructions from preventing that from occurring.
Thanks, Nick. Given standard and high volume accreditation now impose essentially the same employer obligations, what does an upgrade application actually entail?
So that is just it's pretty straightforward, really. It's just letting us know that you require it, so that we can record it as a high volume accreditation application in the system, or a high volume accreditation in the system. So it's so from the point of view of a compliance requirement, that is very, very straightforward.
Thanks, Nick. You mentioned that there cannot be bonding agreements. Can you elaborate on this? It is common to have settlement fee bonding in the medical sector, for example, and there are government departments with bonding in their employment agreements, police, defence, etc. Will these need to be removed only for migrants?
That's a really good question. My understanding is that that is correct. So if a public sector organisation is hiring somebody and they would normally have bonding as part of their employment agreement, that if they're looking to employ somebody under with this visa, they would not be able to apply those bonding arrangements. But that's what I might take away and just double check.
Excellent. Thanks for the question. Apart from those 6 visa categories being replaced, if the employer wants to sponsor a migrant on another visa category instead of the AWEB, specific purpose work visa, for example, does the employer need to be accredited?
No. So accreditation is only mandatory for that visa type. So if someone's coming in for a specific purpose, then that visa category will still exist, and the criteria around that aren't changing as part of this work.
Thank you. What if an employer has 5 AWV holders and one leaves their employment? If the employer wants to assist with a further AWV, does that mean they will need to apply for high volume? In other words, is it employing 5 or assisting 5?
So, Lena, it's 5 at any one time, right? So if they're replacing one with another, they wouldn't require high volume?
The quota that job quota kind of works when the job is associated to the employer, which will happen when the job is approved. So if the migrant still has an AWV that's connected to the employer and they leave the employment, but they haven't had a variation of conditions to work for another employer, or their visa hasn't expired, then they will still be connected to their employer and taking up one of those spaces.
Right. So yeah. The question is, if the visa is still current and the visa still records them as working for that employer, then that would count as a 6th. But if they've moved out of that role and obtained a new visa or a variation of conditions which moves them from that employer, then they wouldn't need to upgrade. They'd just have 5 visa holders. So does that make that? Yeah, that makes sense to me.
Yeah. It does make sense. Thanks, Nick. Who precisely is captured by making hiring decisions? Is everyone who takes part, e.g. in an interview, considered to be a part of making the hiring decision, or are we just talking hiring managers, owners, HR?
So it's mainly that's a really good question, and this is kind of where the line gets drawn. We all need to provide further guidance in terms of how we are going to be operationalising it via our SOPs. My view on it is that it's the hiring manager who's the most important person there, and the HR areas. So if you're on an interview panel, that's slightly different from being having that being responsible for that person's employment, signing the employment agreement, and being their day-to-day manager. So as I said, this is something that we'll need to clarify to provide kind of absolute certainty, but it'll be it wouldn't be someone who's not a manager, for example, who's been brought onto an interview panel and helps make the helps do the assessment. It's the person who ultimately has got management responsibility for that individual, and people who are part of the recruitment process, like the HR team.
Nick, quite a common question. The viable and genuinely operating business requirements may exclude lots of businesses who have suffered during COVID. Will there be exceptions made for businesses which have been particularly impacted?
Not in instructions. So we would assess an application on its merits, and where the processes around exceptions might be warranted, they can be applied. So where discretion is normally built into the system, it will be there, but the instructions won't be explicit about that. So those financial requirements will need to be met, and that's in order to ensure that the migrant's going into a job with an employer that's financially sustainable, is going to be able to keep paying their wages.
Thank you. I'll hand back to Matt Gibbs now, because we're actually on time, and thank you very much to you and Lena for answering those questions.
All right. Thank you very much, Nick. I think that's certainly extremely helpful to our audience. I know that there's still a number of questions that we haven't been able to get round to. As I say, all is not lost. We will take those questions away and they will help us with our key messaging. It tells us more about the information you need to know about, which we can include on our website. And questions that weren't quite specific about employer accreditation today, there's one or two through our chat here, through the Q&A, we'll pick those up and be able to answer them when we have our second webinar on the job check and visa application. Just to reiterate, we are recording, so you will be able to go back and see this. There was a lot of information we gave you here. We recognise that was a lot to take in. So please feel free to check out both the website and the recording once we've made it available to you. And we will be doing that as soon as we can.